the various other international forums. And Jyoti, we have a commentator from the Human Rights Office with the experiences in Sri Lanka also and Nepal, and she can well give Dr. Vidya Kishore Rai.
Namaskar to everybody. I am Vidya Kishore Rai Bimal from the Faculty of Law. Of course, it is a matter of great pleasure for me to have the chair of this qualitative and prestigious session, and the session is on socio-economic rights and their enforcement. And we are having two presenters regarding the issues. One is Mr. Vicente Claderhead, and he will have his deliberations on enforcement of socio-economic rights under the draft constitution. And the other eminent personality is Dr. Mario Gomez on comparative experiences with regard to social economic rights. These two presenters are here, I think, and we are having three commentators, and I see that they are all from our country. The first one is Vinod Chaudhary. I think that he will be coming. He's not here, and he is the CA member, eminent constitutional expert advocate, Dr. Bhimarjun Acharya. And the next one, Jyoti Sangahara of HCHR. So we have this framework, and particularly we have the time constraint. We are half an hour late. It is 11:45, and it was required to be conducted at 11. So we are quite late. So I will request the paper presenters as well as the commentators, by taking into consideration the time constraint. And for this, first of all, I will like to request Mr. Vicente Claderhead on enforcement of socio-economic rights under the draft constitution. That is in the process, and not going the time frame beyond from 15 to 17 minutes, and that is to be taken duly into consideration by the paper presenter, Mr. Vicente Claderhead, on enforcement of socio-economic rights under the draft constitution.
Country Director for ICJ Nepal. I've chosen to stand up this morning for a couple of reasons. One is that having sat primarily at the back of the room yesterday, it appeared to me that a lot of the time we couldn't actually see the speakers. So in an effort to facilitate that, I've chosen to stand up, but I promise you that that doesn't mean that I'll speak for a longer period of time. As with several other speakers, I am from Canada, and I am very pleased and privileged to have been asked to speak at this event. It is a tremendous honor, and I speak to you honestly in that way. I also want to say that I don't come from Canada from the perspective of saying the way we do things in Canada is the way you should do them. I don't come from that perspective. In fact, I come from a different perspective, one that says, in all honesty, the way we have done things in Canada, and I'm particularly thinking of Aboriginal people in Canada, I also am of the view that when it comes to fundamental rights in Canada, we have made several mistakes. In our Constitution, in our Charter of Rights, the economic, social, and cultural rights are not explicitly laid out, and that, I say, must be seen as a mistake. And I urge you, as someone who has only worked with poor people for the last 25 years, I urge you not to make the same mistake. Copies of my presentation are being distributed, but what I want to say is I've divided into several parts. The first part is, why are ESCRs? Why are economic, social, and cultural rights needed? I think they're needed for several reasons. If we look historically at Nepal, women, ethnic groups, caste minorities, people with disabilities have been subject to terrible social injustice. The history of Nepal is a history of social injustice for equality-seeking groups, for minorities. That's one reason. If we look currently at Nepal, moving things forward, let's take just a very quick snapshot. And on my presentation, you'll see a list of things. But let me just look at a couple. Last year, in May through August, there was an undeclared cholera epidemic in Nepal. About 400 people died from it. And of those 400, when we break down the numbers, we see that even though Dalits were less than 15% of the total population in the affected districts, they made up almost 40% of those affected. There was a disproportionality. To anyone looking at it, you need to ask the question, why was it that Dalits were far more likely to have died? And then you'll see on my presentation, there are other ones. 43% of Nepali adults are illiterate. Of Nepal's 29 million population, only 1.6 million households have access to electricity. And it goes on and on. So not just historically, but the current picture is one of social injustice. A third reason, and as a newcomer to Nepal, I say this with some modesty, but when I've spoken to people here from all sectors, from all political perspectives, I ask about the conflict. What are the roots of the conflict? And to my amazement, what I find fascinating is that all perspectives say one of the most important roots of the conflict was social injustice, was poverty, was marginalization. Those were the roots of the conflict. And so I think that that is another huge reason why those roots, the social injustice roots, must be grasped, the nettle must be grasped and reflected in the new constitution. The last reason is that, as with many other forms of human rights violations, they often arise from political marginalization, social marginalization, voicelessness, people without a voice in the political process. Everywhere in the world, including in democracies, have experienced human rights violations. There's no democracy anywhere in the world that has not legislated and enacted human rights violations. And the reason often is because those whose rights are violated do not have a voice politically. And so when we bear that in mind, it makes all the more reason why those who don't have a political voice should have recourse to the courts to ensure that their fundamental rights are protected, because history has shown us that politically and historically, they do not have access to the political process. Political elites have shown historically they are indifferent to those who are most marginalized. As a result, those who are equality seekers need to have access to an independent body which will enforce their rights. Just briefly, what are social and economic rights? The rights, for example, to food, to clothing, to housing, to health care, to education, to employment. These are the kinds of rights that are required to be protected in order to live a dignified life around the world. Notably, South Africa, applying those rights and showing the rest of the world that those rights can not only be protected, but also applied. So the right to housing, the right to food, the right to water, the Constitutional Court of South Africa in a way that has become meaningful for those who are most. What kind of duties do ESCRs impose on governments? What is the nature of the bottom of the second page of my remarks? It's to apply the maximum of available resources. Progressive realization using the maximum of available resources. Right to food. Short answer, a non-legal answer would be to say Government must do what it reasonably can. They need to be able to go to court and hold government accountable for its lack of action. They need to be able to go to court and say, my rights have been violated. I want a judge to look at the evidence, to look at government's responses, and to say whether that's reasonable in all the circumstances. No more and no less. The fact that this can be done is shown in the South African experience. And in the third page of my remarks, you'll see there's a recent case from South Africa where people in Johannesburg said that they were not getting enough water. The government quota, I think, of 50 liters either per person or per household per day was inadequate. They filed a claim. The claim ended up in the Constitutional Court of South Africa. The court then looked at all the evidence. The plaintiffs went forward, filled all the evidence about the inadequacies, the unreasonableness of it. The government came forward and said, with respect to water, we have a program, we have targets, here's how we have prioritized disadvantaged groups, here's the resources we have available to fulfill these rights, we're doing what we can. And at that point, the court looks at the text of the provisions and then asks itself whether government's efforts have been reasonable, taking into account its resources. And so you'll see in the quotation there on the third page of my remarks from the South African case called Mezibuko. In the second paragraph, the court says, in doing so, this approach enables citizens to monitor government's performance and to hold it accountable politically if the standard is not achieved. This approach, and meaning the ESCR approach, also empowers citizens to hold government accountable through legal challenge if the standard set is unreasonable. In other words, the court can and does and will hear the evidence about whether government has done all that it can, and then decide whether those efforts have been reasonable, taking into account its resources. And again, I'm repeating myself here, but this comes from a perspective that says historically, the most disadvantaged, the most marginalized, a recognition that governments, democracies will very often take action or fail to take action, which may be acceptable to the vast majority of people, but which time and again either disregards or overwrites the interests of marginalized groups and equality-seeking groups. So are ESCRs possible in a poor country like Nepal, like many other countries? Is it possible? And when Justice Zak Yaqub from the Constitutional Court of South Africa was here this summer, he was asked that question, and he said, it's especially in a poor and least developed country such as Nepal that you need ESCRs. It's especially here. Because they are, disadvantaged people are far more likely to be politically voiceless, to be on the margins of the political process, and to having their interests and rights neglected by political elites and policymakers. So in that context, it would not only be pointless to look at the political process, it makes sense to have another avenue, a judicial avenue, for people to resort to. Okay, so let me comment on the draft that has been released by the Fundamental Rights Committee. And I want to say, first of all, that how proud Nepalis should be for what is a remarkable concept paper that shows a lot of commitment and dedication to the concerns and interests of all Nepalis. I frankly think that it's a tremendous effort, and members of the committee and Nepalis generally should be very pleased. Let me offer, however, some constructive advice and recommendations. And I've set them out in my paper, the last 2 or 3 pages, on the equality rights provisions. When you look at it, and go to the CCD website, the Center for Constitutional Dialogue, they have an interesting page there that has previous constitutions from Nepal. Compare the equality rights, the anti-discrimination provisions, to that which existed in the 1990 Constitution, to that which existed in the 60s, and going back to 51. Lo and behold, the wording is pretty well identical. And so from a real-world point of view, ask yourself the question, if discrimination against women on the basis of caste, on the basis of disability and so on, have been prohibited for 50 years, why are the problems just as pervasive as they were 50 years ago? And I think the answer is it's a several-fold answer. Part of it is implementing and enforcing laws, and for sure that's a problem. I think another thing that it points to, however, is that the text of the provisions needs to be strengthened, more robust. It needs to take on not just formal equality that prohibits laws which single out particular groups, but it also needs to require substantive equality. And that, I understand, for many people is a kind of a new idea, a vague idea, an abstract idea. It's about looking at the